Our final case this morning will be People versus Devaun Lopez.
Good morning, Your Honors.
Just barely.
Pardon?
Just barely. Good morning, you said.
Oh,
2 minutes. So what he's saying is 11:58. Not that it's barely
thanks.
a good morning.
Right.
We really worked hard all morning, and it's just slightly better than good. It's barely good morning because you have 2 minutes.
All right, well then hopefully by the end it'll be a good afternoon also.
We'll get off to a good afternoon.
Would you like to wait 2 minutes to start?
No, sir.
Okay,
No,
let's
sir.
proceed then.
Good morning, Your Honors. Nathan Collison, Saginaw County Prosecutor's Office, appearing on behalf of the appellant. Seated to my right is my colleague from the Prosecutor's Office, fellow assistant Melissa Hooper. Your Honors, I'd like to begin with the people's position that the Court of Appeals erred when it found that witness Dennis Hoskins' unavailability was caused by the procurement or wrongdoing of the prosecutor. And also that the Court of Appeals erred when it found that the prosecutor, the conduct or statements made by the prosecutor constituted threats or intimidation. Now, I thank the court for granting us the opportunity to come and address these issues today. And in doing so, they ordered some supplemental briefing regarding the issue of intent, and specifically a test in order to determine what type of intent is necessary, if any such intent is. In order to fully flesh that out, I think that I need to clarify the timeline of events in this case, because I don't know that the parties' pleadings were specifically clear. The comments in question were made the morning of March 10th, 2015. And we know that because if we look at Volume 1 of the trial transcript dated March 11th, 2015, the prosecutor addresses the court wanting to discuss a conversation that took place, quote, yesterday morning, which would have been the day before. And as a result of that conversation, at the first day of trial, the defense attorneys for the co-defendants accused the prosecutor of threatening and intimidating the witness. That is very important because if that happened the morning of March 10th, which the record reflects that it did, the witness took the stand that afternoon. We have a transcript of that, where he decided that he was going to testify. There was no mention of any threats or any intimidation. And having said that, there's been this mischaracterization of the timeline of events here. Now, moving on, it wasn't until 3 days later, on the 13th, that the witness decides he doesn't want to testify, and he's doing so because of threats that he received from the prosecutor the morning of the 10th. Now, the motion that was scheduled to be heard the 10th was on the people's motion to declare the witness unavailable. And that was because the prosecutor had received communication from the witness's attorney, Mr. Robert Dunn, indicating the reluctance of the witness.
So, counsel, I have a question. Good morning.
Yes,
and welcome. The question I have is, you were indicating that he had received this from the attorney. Why did the prosecutor in the first place, if the person has counsel, why did he approach him and indicate that he could face life in prison?
Your Honor, that is an excellent question, which has not been fleshed out by the lower court record. This record is devoid of any type of proper evidentiary hearing to determine what the impetus was behind the prosecutor's actions, and also what reaction that impetus may have had on the witness. Now, from my understanding, at this meeting on the 10th, the witness's attorney was not present. And the prosecutor, as case law supports, has the ability to acknowledge the certain penalties that are imposed when you lie under oath. As a matter of fact, every time you testify in court, the specter of perjury looms over said testimony. Now, getting to the court's questions regarding whether or not intent is required, and if so, what is the test to determine it, I think that my brief pretty well covers our position. I believe intent is required, otherwise the court rule would not include the language for the purpose of, and I think that that intent that is required is specific. And in order to draft a test, I looked down the line in 804 to 804B6, which, while they present different relief, I think the notion or the concept that underlies that rule or that section of the rule is the desire to dissuade people from making witnesses unavailable. Now, on the one hand, we have the 804A language, which is inclusive or exclusive by nature, and we have the 804B6 language, which is exclusive, but they're underpinned with the same motivation. They have the same intent, and that is to let witnesses testify without threats or intimidation or pressure that they either change their story or remain unavailable. And having made that correlation, turn the court's attention to its opinion, People v. Burns, which is a 2013 opinion, which does a great job of distinguishing negligence from specific intent. Specifically, they talk about the interplay between the defendant's knowledge, or rather that the proponent of the statement's knowledge may cause unavailability versus the intent to actually cause it. It's a very clear delineation. And by way of stating that if a person would reasonably foresee that their wrongdoing might cause the unavailability, the distinction that is separate and distinct from whether the defendant intended to procure the declarant's availability to testify takes this problem out of the realm of negligence or general intent and puts it squarely in the realm of specific intent. And the test that I have presented to the court, I think, not only draws on this court's prior opinions, not only draws on the established nature of...
So, counsel, should we then just assume that there was no intent? And would that be my assumption? Would the assumption be that there's never any intent unless we can show intent?
Your Honor, I think that the assumption should not be that there is no intent, just like the assumption should not be that there is intent. The defendant has gone to great length to characterize the statements as obviously having the intent of rendering the witness unavailable because of the weight of the evidence, because of credibility issues and the substantive sufficiency of the evidence. I think that just like we don't want to assume that it's not a threat, we don't want to assume that it is one either. And that's why there needs to be a concrete test that this court puts forth in order to determine whether or not there was. Just because you say something...
What would that look like? I mean, how would you do a concrete test to demonstrate intent? Like, what would you suppose that would be distinguishable from the Court of Appeals?
Well, as I've included in my brief, the test that the people propose is that the court finds by preponderance of the evidence that the proponent of the statement procured or engaged in wrongdoing, number one. If not, the analysis ends. If so, we move to prong two. That, based on the totality of the circumstances, again by the preponderance of the evidence, the procurement or wrongdoing was specifically intended to prevent the witness from attending or testifying. And if that cannot be satisfied, the analysis ends. But if we have established that by the preponderance of the evidence, then move on to prong three, that the procurement or wrongdoing did actually cause the witness's failure to testify. And that is the test that this court put forth in Burns regarding the 804B6.
And that requires an evidentiary hearing.
Yes, sir, it does. And I think that if we look at the record, what we have is we have this quasi-evidentiary hearing that took place where on the first day of trial, actually, on the 11th, where we had three people say, well, actually two people say that the prosecutor threatened and intimidated the witness. Conveniently, those two people were the defense attorneys for the co-defendants. We also had two people that said that the statement was made in a fashion just as I'm speaking to you today, and those people were the prosecutor and the chief investigative officer who had investigated the case and was present during the time the statements were made. Now, none of these people were under oath. Not that I'm questioning their credibility.
Does it matter whether the statement is in fact correct that the prosecutor made about facing life in prison?
I think that's a very, very good point. I don't know, the statement is only incorrect if he lied at the preliminary examination. So the prosecutor is faced with the situation where
I
he
thought it was
has,
the opposite. I thought it's only correct if he lies at trial.
if
If he lied at the preliminary exam, isn't he only facing 15 years?
it's 15 years.
So when you
No.
say you could be facing life, that assumes you're going to lie at trial. So
Exactly.
So the prosecutor assumed he told the truth at the preliminary exam.
He did.
Well, I don't know how any of us know that, right? I mean, that's.
Well, you're right.
You've
that's
you've
the
probably
crux.
known witnesses who have lied in court.
Your Honor, once I became an attorney, my grandfather practiced law in this state for almost 60 years. And when I became an attorney, the one thing he told me was you have to assume that everyone is lying to you until you can prove otherwise.
So all I'm saying is I don't know. I mean, I don't have any. I don't have any way to look inside his soul and know whether he was testifying truthfully.
And you're
or
absolutely
not.
right. You're absolutely right. We're not omniscient individuals, not even the learned justices that I have before me. But that is the crux of every instance of perjury, right? You always have that question to resolve. At what point did the lie happen? Was it at the original testimony given under oath, or was it at the later testimony given under oath?
Right.
That's the challenge that a prosecutor has with every perjury case. But in this case, we have a defendant who made a proffer agreement and signed it under penalty of perjury, which was explained to him in detail. He then gave consistent testimony at a preliminary examination, also under oath, subject to the penalty of perjury. So was the prosecutor outside of his general realm of perception by assuming that any testimony inconsistent with the preliminary examination would be a lie when he had already testified twice to that same substantive series of events?
Well, counsel, were you embarking, maybe I misunderstood you, but were you embarking upon the suggestion a few moments ago that a loud voice on the part of the prosecutor or stern demeanor or hand gyrations or very forceful words could transform into wrongdoing, something that was not otherwise a wrongdoing?
Your Honor, I think that the key here is ascertaining the intent, whether it be words, body language, action, or otherwise. The nature of this case is that the Court of Appeals seemed to gloss over the fact that the trial court never found that the witness was actually threatened. He found that the witness felt threatened. And as I detailed in my brief, basing something on something as subjective as feelings cuts across the totality of our state's jurisprudence. We have a duty to objectively verify facts and to make rulings and conclusions of law based on that.
Is it a threat that may result in wrongdoing on the part of the prosecutor to communicate very directly and forcefully to a witness what the law is in our realm concerning perjury?
Only if they have the intent to prevent the witness from testifying. Only if those statements have the very specific intent of procuring the unavailability of the witness.
Is there a distinction between an intent to prevent the witness from testifying and an intent, as might have been true in this case, to ensure that if he does testify, it be undertaken in a truthful manner?
I think that what the prosecutor wanted was the witness to testify truthfully. I think he wanted him to.
How do we make that distinction?
What do the people gain? What does the prosecutor gain from making this witness unavailable? On the one hand, defendant argues he now has the ability to read that preliminary examination testimony in the record and preclude any further cross-examination. However, the same thing could have been done, and it could have been just as effective if the witness got up and lied, because he would have been able to use that preliminary examination to impeach him and thereby let the jury make the credibility determination. Let the jury decide which version is the truth. Either way, we get to the same result. The testimony comes in.
Counsel, the Court of Appeals also held that the defendant's due process rights were violated by admitting the preliminary exam, given the way in which the witness became unavailable. And I know that wasn't specifically in our MOA order, but I'm interested in your thoughts on the defendant's due process claim.
Thank you, Judge. I think that issue is only determinative if we find that the unavailability was caused by the prosecutor.
So that's not true, because there's about, I don't know, 700 cases at least that cite United States v. Webb. There's a robust,
Yes, ma'am.
a robust doctrine around when perjury is explained to a witness and the witness doesn't testify. And there's lots of factors courts look to, as you might imagine. They're pretty fact-specific. What was the language used? What was the tone of voice? What did the prosecutor know about what the witness was planning to do or say? So none of them are dependent on a state evidentiary rule, because obviously a constitutional claim would trump a state evidentiary rule that prevented it. So that's not, it can't be, we don't have that easy way out.
Absolutely. However, I would like to distinguish Webb, and I'm glad that you brought that up, because Webb, in addition to cases cited by the defendant, including Callington, Williams, Pena, and Washington, all involve defense witnesses. They all involve situations where a prosecutor did something which was determined to have made a defense witness unavailable. And Webb hinges on the idea that a defendant has a right to present a defense. And they specifically say that they have the right to have witnesses come and testify on their behalf.
So I agree, and I actually think that is one of the relevant factors in this case, because, and frankly, I'm not sure why defense counsel didn't say, we want to call him and make him a defense witness. It would have improved their due process claim.
I don't disagree, Your Honor.
I also don't understand why, when counsel said at the end of, when counsel was complaining about the evidentiary rule, he said, I understand that's what the rule requires. I don't like it because there's a lot of additional impeachment material that has been unearthed since the preliminary exam, but yet counsel did not make a complaint about this problem under the Sixth Amendment either. We don't have a confrontation claim preserved. We don't have a due process claim preserved, although the Court of Appeals did find one. But it's not the case that every case that cites Webb says it doesn't apply, only applies, the defendant only has a due process right if it's a defense witness. That limiting principle just isn't in the doctrine. So that's not quite enough. What more should we look to figure out if there is a constitutional problem with what happened here?
I think that it turns back on the idea of if intent by the proponent of the statement to make the witness unavailable is a determining factor. If this court in Burns went to great lengths to specify that there is a difference between knowledge and purpose, and that knowledge implicates an idea of foreseeability, this court excluded any element of foreseeability in the 404B or 804B6 analysis. And by doing so, they eliminated any negligence component and instead focused on the specific intent, the purpose with which the statement was made, not the knowledge of the end result that the statement may create. And if Your Honors have no further questions, I'd like to save the remainder of my time, if there is any. Thank you very much.
Thank you,
It's been
Mr.
a pleasure.
Collison. Mr. Ambrose?
Ronald Ambrose appearing on behalf of Mr. Lopez. And what I wanted to address is, I think the first line of the Court of Appeals decision is under the due process clause of the 14th Amendment. And I think everything from that flows down to the court's interpretation of the actual court rule. The statements that were made by the prosecution, it was not for the purpose of encouraging Mr. Hoskins to testify. It was sent there with a more or less direction that this is what they were going to do. They were going to charge him with perjury if he testifies, and that's what Mr. Hoskins states, that he was threatened with life in prison if he testifies. And under the court rule, I don't think we need to add anything else to it. The court rule is right there under the plain language of the court rule is that made this witness unavailable, and that the witness or the preliminary examination testimony shouldn't come in. And if the prosecution wanted Mr. Hoskins to testify, they wouldn't have made that statement, first of all. And their remedy would have been to impeach him with his prior testimony. And, you know, if he had changed his testimony at the trial, which it seems like that he would have. And I think the prosecution more or less made that statement because the evidence against Mr. Lopez was thin at best, is the quote from the Court of Appeals decision.
Mr. Ambrose, how would we ever know what the prosecutor's purpose was for letting the witness know what the penalty for perjury was? I mean, I might assume the prosecutor wanted to make sure the witness did testify, but testified consistently with what he said at the preliminary exam. That might be what, if I were the prosecutor, I might rather have a live witness saying what the witness said at the preliminary exam. And if that was the prosecutor's purpose, then there's then the rule is problematic for your client, isn't it? In that case, it's not, the prosecutor's purpose was not to keep him from testifying. It was, in fact, he hoped to get him to testify, just consistently with what he said at the preliminary exam.
The prosecution thought, I mean, if we want to get to it, the prosecution thought he was going to change his testimony. And
I definitely know they thought he was going to change his testimony, but that doesn't mean what but my question is, when the prosecutor says, just so you know, here's the penalty for perjury, perhaps what the purpose was of saying that was to make sure he testified consistently with what he said at the preliminary exam.
And
that might have been the prosecutor's purpose. If I were the prosecutor, that might be my purpose. I want to make sure I have a live witness on the stand, and I want him to testify consistently with what he said at the preliminary exam. That's better for me. I have a live witness saying that's the guy that you know.
yeah, but this is a truth-bearing function. And the reason why, I mean, if we want to really get down to it, the reason, Mr. Lopez is not charged in this offense for some time afterwards. It's only after Mr. Hoskins gets arrested and says, hey, I have some information about these two other people.
I fully understand the problems with Hoskins' testimony.
Right.
I'm just trying to, I want to like just plod through like that there's this rule and it has these parts of it, and there's one part of it that the Court of Appeals didn't analyze, and so I'm trying to figure out what from this record could help us know what the prosecutor's purpose was, and I don't believe I can know that from this record. Is that, do you agree with me that it's not knowable from this record?
Oh, I don't agree with you.
Okay.
I think it's pretty clear, and the trial court judge found that
That the prosecutor's purpose in telling the witness what the penalty for perjury was that the witness not testify?
The trial judge found that Mr. Hoskins was threatened, or felt threatened.
Yep. And that's and so the Court of Appeals did a thorough job on the first part of the rule. It's the for the purpose of that we're just focused on today.
Well, for the purpose of making sure, I mean, they made that statement for the purpose of not having Mr.
Well, how did the trial court determine the purpose? There was no finding of purpose.
Well, and I think that's where it more or less gets confused, because the trial judge did find that Mr. Hoskins felt threatened. It just, I guess the trial judge didn't.
If I know that I'm going to lie and go to prison for life, I might feel threatened too.
Right.
But I might then tell the truth.
Right.
Instead of lie. So the threat is not enough. It's what was the purpose?
Well, the purpose was to send a message to Mr. Hoskins not to testify.
But
Based on what in the
message
record?
can't be that you don't testify. The message has to be, I mean, the message has to be a specific message. The purpose has to be that he not testify. And what if the purpose was to make him testify consistently with what he said at the preliminary exam? Whether you believe that was true or false at the preliminary exam, I grant you, I don't have any way to know whether Hoskins told the truth at the preliminary exam, and I understand there are lots of reasons why a good defense lawyer might have been able to show that he did not. But I don't know how I can know that the prosecutor intended for him not to testify at all versus to testify consistently with what he said before.
If you look at Webb and you look at Pena, and those are the two,
So now you're into due process territory, which is where I wanted to go next. So let's just go there. Go. Give me your best due process. How many due process bars for me?
It's unnecessary for the prosecution to make any type of these direct statements to a witness, because as the prosecutor already says, everybody knows that you face potential perjury charges if you lie under oath. So they already had Mr. Hoskins' testimony, and what they did was deny Mr. Lopez his right to present a defense, because.
So I actually believe you're in like really interesting territory here. I do believe that there are potential due process issues, potential right to present a defense, Sixth Amendment issues, right to present a defense issues, potential cross-examination issues lurking in this whole problem. And the trial counsel put some of them on the record without identifying them as constitutional claims, right? The defense counsel said, I don't like this rule. I'm living with it. I don't like it, though, because I had all this other impeachment material I would have used if the witness testified. So the prosecutor's getting a boon by not having him testify, because they get a cleaner transcript than they would have had if he testified. But none of those records, none of those objections were wrapped in any of the constitutional envelopes that you are now giving them to us. And we don't have, a lot of information about how those would have gone. So that I take the defense counsel's word that there was extra impeachment evidence that came up after the preliminary exam, but he doesn't say what it is. So I don't know specifically what he would have cross-examined about. And he doesn't say, Judge, I want to make him my witness. I want to call him as my witness. He's a defense witness now. I have stuff that I want to be able to ask him. So what do we do with the fact that we don't have any of that preserved?
Well, I think if it's as Mr. Hoskins was, a primary witness, that's endorsed. So I think as a defense attorney, you're more or less counting on that witness being presented in the trial.
Yeah. Okay. I understand.
I don't have anything I don't have anything further.
To put this in the most unambiguous and I think straightforward terms, is it a violation of 804 to straightforwardly and forthrightly communicate to a witness whom one sincerely believes will testify falsely that he should not testify on account of that? That's the only information I want to give you.
Okay. I think it's a violation.
That's a violation to do that.
Absolutely.
Why again?
Because you don't need to, the prosecution in such a case doesn't need to say that. Everybody knows that. When you put up your hand, you're testifying as to the truth, the whole truth, nothing but the truth. So the prosecution, by making that overt statement, just as in Pena, was a letter. In this situation, it's a real person in their face saying, hey, if you testify differently, you're getting charged with perjury and a life offense.
Does the tone of voice matter?
Oh, I think yes. Well, I shouldn't necessarily say it that way. I think that makes it quote unquote wrongdoing rather than just procurement. So.
Okay. Any further questions? Okay. Thank you, Mr.
Thank you.
Thank you very much.
Thank you.
Okay, we will stand in recess until 1 o'clock. Thank you.